Hello and welcome. Good evening. This is attorney Brad Micklin. I'm the managing member of the Micklin Law Group. We are a law firm concentrated in divorce, custody, and family law issues and located in Nutley, New Jersey. This is our monthly webinar series. Tonight's webinar is Seeking an Uncontested Divorce, Learn the Basics. I'm going to ask if there anybody on the call right now that can just type me a message in the channel that you have so I can make sure that the video and the audio is working. All right, so I'm going to jump right into it. Let's move right ahead. Let me first give you some information about today's webinar. It is scheduled for 60 minutes. Sometimes it's less, sometimes it's more. I never really know. I do my best to keep it within that time frame. You'll see it's a one-way communication, so hopefully you can hear and see the visuals, hear the audio and see the visuals. If at any time it doesn't, you should have a chat panel, usually on the right side of the screen, that you can send me a message and let me know that there's a problem with either one of them. I will be taking questions, but I wait until the end of the webinar to do that. So if you have one, again, post them into the chat panel. There's a portion for questions. I will take as much time as necessary to get to all of them, but I recommend you do that throughout the webinar so that you don't forget about it or we move past it and you don't get back to it. And like I said, I'll take whatever time is necessary to get to it. You'll see the PowerPoint presentation is attached to the bottom of your chat panel so that you can download the slides or print them if you're interested. And this is also being recorded. It will be uploaded to my website and all my social media, usually within a week or two. The intention behind the webinars, I started doing this, is because it's very difficult when I meet with clients to really give them all the information that they need about their case. So I now create these webinars. I also have a ton of content on my website, micklinlawgroup.com, so that there's resources available that you can go to and get answers to your questions, even if I'm not available or even if you're not hiring me, just so that it's there. Which turns me to the purpose of today's webinar. Today's webinar is actually for those people who are not hiring a lawyer, usually not hiring a lawyer and looking to go forward on their own and do what they believe to be an uncontested divorce. Now, a lot of people believe that, well, oh wait, I was going to start talking about it, but let's just hold on. Give you a little information about me. This is me. If you haven't worked with me or met me, this is your first meeting. A little bit of my background. I am a member of the New Jersey State Bar Association, licensed to appear both state and federal courts. I started my career as a law clerk for Judge Austin in the Superior Court of Bergen County. I then moved on to Kessler & Associates. I did complex commercial litigation for a little while, and then I opened my own office, originally as a general practice attorney, but then I concentrated into divorce and family law, which is what we practice now, the limitation of our office. Here are some of the awards I've been fortunate to receive. I don't put these to impress you, but to impress upon you that I do care very much about what I do. I put a great deal of care into handling my cases and representing my clients, and I just want you to know that you can rest assured that the information you're getting is from somebody who has a good amount of experience and has been doing this for a long time. That being said, let's turn right into what we're here to talk about. Oh, I'm sorry. I forgot the slide was here. This is a divorce and custody support group. I just like to mention it. It's another service I offer without charge to anybody, of course. It's confidential. The webinars like these, the webinars are, online. The divorce and custody support group is actually done in my office, usually the last Wednesday of every month. It's confidential. It's just there for people to come out to speak with like-minded people, hear and share stories, see what people have gone through, share what you're going through, get some advice. I'm here at all of them, so it's also a chance to get some free legal advice. And it's a good experience. I really enjoyed doing it. If you're on this webinar or watch this webinar, chances are you will have received an email at some point in time about the support group. So if you're interested, just let us know. That being said, now let's move into, sorry. Last runs up every month, like I said, 7 to 8 p.m. Our address. Do you want to just take a second to jot that down? All right. Now, what we're going to cover. Now, first, the reason I was starting to say before, a lot of people talk about uncontested divorces and they believe they're going to have one and it's not. I mean, if you have some issues or you don't have an agreement on something, you have a contested case. An uncontested case is when you have an agreement. Now, most cases become uncontested because at some point in time, you reach an agreement. But if you don't have one and you have issues and complications, you technically have a contested divorce. So the purpose of today's seminar or webinar, what we're going to talk about, are the issues to decide whether or not you do or don't have one and how you can guide yourself through it if you do. So some of the things we're going to talk about first, are you a good candidate? Like I said, depending on the types of issues and the finances and the relationship will help you determine whether or not you are. Next is how to create a custody and parenting plan. There are a lot of issues to custody and parenting. It's obviously one of the most significant issues to a divorce or even a custody case itself. So we want to make sure that you're well versed in what you're going to be dealing with. Look at the tax aspects of some of the decisions that you're going to be making if you are doing this and you are doing it on your own. And again, this webinar is intended for those that are not going to have an attorney. So most of my advice is going to be geared towards that direction. Next, we'll be talking about equitable distribution of your assets and debts, how to understand it, how to do that. Preparing a written property settlement agreement, which takes your contested case to become an actual uncontested case. When alimony payments make sense, give you some guidelines, basics for drafting a complaint, which is what you're going to need to file your case. Usually that's done in the beginning, but sometimes it's done after an agreement is reached. And then lastly, what you can expect at your court case. All right, so let's first talk about, are you a good candidate for an uncontested divorce? First, you want to, if you have a short-term marriage, suggest that you'll have fewer issues. And ultimately, that's going to be what helps to determine whether or not you're a good or bad candidate. Fewer issues. So a short-term marriage suggests that you might be. Fewer assets, little debts. Less to divide, less contact afterwards that you'll have to have with one another, whereas if you have assets and debts, often that keeps you at least in contact for the payment arrangements and divisions afterwards. Kept your finances separate, didn't commingle any assets, paid bills separately, deposited checks, even sometimes filing taxes separately. But basically, it doesn't have to be all that. But if you basically kept and ran your household with separate finances, separate accounts, it suggests you might be a good candidate. Never resided together. That might seem strange to a lot of you listening, but there are many clients I have. They marry and then they don't live together. Sometimes they're different careers. Sometimes there are religious or cultural differences. Some marriages are still arranged in some cultures. So life circumstances sometimes just leaves parties not living together or not living together for a long period of time, and often with a long separation. Can support yourself without assistance from the other. That would eliminate alimony, which brings us back to having fewer issues. You have a prenuptial agreement, and either you believe it's valid or you're not challenging it, or the other side is not challenging it. That would mean that your issues are resolved, and therefore there would be no contested issues. No children, or they're grown and emancipated, meaning they're out of the house or out of college. You have a good relationship. That's probably the key almost any time of getting either a contested issue resolved or getting through an uncontested divorce. And then lastly, both of you want to move on. You have shared interest in doing what's right and getting through this quickly and easily. Now let's look at when you're not a good candidate. Or not that you can't do it, but that you should strongly suggest you get professional help with this. One, you have high worth. And then I guess that would also mean high debt too, but mostly high net worth, significant assets. You want to know that you're dividing them right and fairly. Complex assets, business interests, and I don't mean like if you're like a contractor or you're like a one-man repair shop with a truck or a consultant, but I mean like if you have like a pizzeria that generates a lot of cash, or you have a storefront with a bunch of employees, these assets would suggest that you should have some legal help. Complex issues. A lot of what we're talking about are complex issues, but complex issues can also be inside of the relationship or the personalities. you just may have some difficulty in coming to an agreement and seeing things eye to eye, so you may not be able to have what would usually be a non-contested divorce. Custody has been disputed. Custody, like I said before, one of the biggest issues, probably one of the most complicated in trying to get a divorce. If custody is going to be an issue, you're not a good candidate. You should have professional help. And when I say professional help, I generally mean legal help, but also expert helps, custody evaluators, psychologists, accountants, things like that. One spouse is a narcissist, and I don't mean just is narcissistic, but I mean is an actual narcissist within the sort of definition of a borderline personality disorder. Not going to go into that here, but I do a great deal of work with narcissistic issues in couples, a great deal of information on my website about narcissism and divorcing a narcissist. But if you have an adversary, a spouse that's a narcissist by the definition and characteristics, you're probably not a good candidate to consider that you'll have an uncontested case. History of domestic violence and an active restraining order. Two reasons. One is if you have an active restraining order, it usually will prohibit communication, which means you can't have issues resolved until you can communicate. And also, just the history of domestic violence, even without a restraining order, suggests that the person who is the victim of the restraining order doesn't have equal bargaining power, usually doesn't have the same bargaining power or power position in relation to the other person, even with the order in place. So it's unequal, and it's usually not going to be fair, so I don't recommend it. If there is hiding of assets, either assets that have disappeared, or there seems to be divorce planning, like, spending is increased, work is decreasing, a business is not generating the same kind of income as it used to be, overtime disappears, things like that suggest that you may have somebody who's trying to sort of pull a fast one, and you're not likely to have an uncontested divorce, or at least a fair resolution and an uncontested divorce. Unequal playing fields and access to funds. Now, this goes a little bit to what I said with domestic violence, but more about the practical aspects of your life. Do you have equal access to monies? Do you generate similar income? Do you have access to the party's assets and incomes? Do you even know where they are? If you're not in the position to have access and understanding of the family finances, it's not likely to be a good case to consider that it'll be uncontested. One spouse is breadwinner, one stays at home. That goes a little bit to what I was just saying, the unequal position and access to funds. In this kind of traditional situation, that's often what we will see, and therefore it's not likely to be a candidate for uncontested cases, or to be an uncontested case. So moving on now to the issue that I said is probably the most significant, and that is your custody and parenting time plan. Now, and they're both separate because they're very significant. And there's a lot of terms to it. I'm going to give you a brief overview of these terms. I usually tell my clients to stay away from terms because they're hard to understand, and if you ask for the wrong thing, sometimes you get the wrong thing. But at the same time, if you're going to be doing this on your own, you do need to have an understanding of that. So first, there's legal and physical custody. Legal custody is the right to make decisions. Physical custody is where the child's going to reside. Next is sole and joint, and obviously these relate. So you can have sole legal or sole physical, or you can have joint legal or joint physical. Most commonly, you're going to have joint legal and physical. And what that means is joint legal means you both participate in the important decisions, religion, medical, education, residence, equally. Joint physical means the child resides with both of you. Does not mean equal time. If you have a parenting time schedule where one parent has 364 days a year and the other parent has one overnight, that's still joint physical custody. It's just not equal. It's grossly disproportionate. But it is, for the legal term's sake, joint physical custody. Another important distinction is major versus day-to-day decisions. You will have, if you have joint legal, let me go back. If you have sole legal custody, then that person with the sole legal custody makes all the decisions without input. Major versus day-to-day decisions. If you're sharing joint legal custody, as I said a moment ago, you are supposed to participate in the important decisions like religion, education, residency, school. But day-to-day decisions, you don't necessarily, because the parent that has custody has the obligation, like getting them to school in time and taking them to visits and things like that. Now, that gets a little muddied because you'll be sharing physical time. So day-to-day decisions could be what daycare you use because you want to pick the one in close proximity to your house, or what doctor that you go to. But medical could be significant, so it's a careful balance between the two. But you should understand at least the distinction because it will affect your joint custody rights. This is 50-50. PPR is parent of primary residence, and PAR is parent of alternate residence. Also, terms that are going to come up in parenting time, custody arrangements, and child support. 50-50 means obviously equal physical sharing. PPR and PAR, parent of primary residence, mean who does the child primarily reside with. Parent of alternate residence is the other parent that the child does not primarily live with. Even in a 50-50 arrangement, you may need a parent of primary residence designation simply because of running child support, but mostly because of registration for school. Sometimes they require that to be in an actual order, so you may need the designation to make sure every time. Willingness to co-parent, very important. When you make a custody and parenting time, I generally tell to my clients that we hope it's like the sort of what I call the basement, the bottom level, the rights that you have if you need to enforce them, but we hope you never have to enforce them. We hope that when you have an agreement or disagreement that you work it out. If there's a conflict where somebody needs to switch weekends because they have a wedding, you'll cooperate, you'll pick up a weekend. That's going to be a very important consideration when you're making your custody parenting time. If you do not have the willingness to co-parent on both sides, you want to have a more rigid plan. And if you do have good cooperation, you won't necessarily need that. Childcare, very important one, because it's going to determine often who is the parent of primary residence and the decisions of where to go. But the cost of it is also going to be factored into child support, or they should be factored into child support. So you need to factor this in for custody and for child support. You should also realize when it's going to end and maybe have a mechanism to change child support without having to go back to court if you know what that date, around that, when that date of child care ending will be. Relocation within and out of state, very, very important issue, very significant. There's a recent decision. I should say recent. It is recent, but you might be watching this at some point later. Bisbee versus Bisbee. I actually represented the father in the trial court. We got the most horrendous decision against my client that I've ever seen. He took it to an appeal. The appeals court reversed it, said the trial court was wrong, and sent it back. Deals with relocation, believed to be making the standard more difficult. I don't agree. I don't think but relocation within and out of state is very important. You may need to consider when you're doing your custody parenting time, if you want to address this issue, it may be also an issue that keeps your case from being an uncontested case because it's significant and will greatly impact your future relationships if you don't plan for and come to an agreement about it while you're trying to solve your divorce issues. Best interest and change circumstances. These are terms that should be embodied in your agreement. They should also be things that are affecting and guiding your decisions both now and in the future. Best interest is always what the court looks to when deciding what's best for a child, what's in the child's best interest. Change circumstances will be the circumstances that allow you to change the agreements that you're making when you're trying to reach an uncontested case. So you want to understand what that is. You want to maybe enunciate them into an agreement so that it's clear what is and is not in your child's best interest, what is and is not considered a change of circumstances. How to create your parenting time plan. So I've given you a lot of terms and a lot of information you should worry about, but what are the specifics that you need to look at? So one first is, and this is going to be aside from obviously your day-to-day schedule, but first you want to do holidays, special days, and vacations. You want to make sure that all the holidays that you feel are important are addressed. You want to have pick-up and drop-off times. You want to know how many days of vacation in the summer, whether or not the weeks are consecutive or not. And Mother's Day, Father's Day, your child's birthday, your birthday, things like that. You want to have those all addressed so that you have a sort of like a grid that you can create of who has what day. Again, they're always free to be exchanged or changed, but you at least want an agreement that says what they are supposed to be. Pick up and drop off. You want to illustrate who is supposed to do that so it's not left up in the air and then you're fighting over who should be doing it. That's enough of that. Flexibility, again, you can try to build in some language into a custody plan, but if you believe you're going to get reciprocity, that's good language to have. You can even build in a mechanism of how days are supposed to be made up, or how disputes are resolved, like a common dispute or common conflict, I should say, is both parents want to have a vacation at around the same week. So how do we pick? You can build into your agreement, who gets the even years and who gets the odd years, or any kind of mechanism that you think will help you in the future. Preference of the child is if of age. Now that's something you're probably going to have to determine. Courts almost never let a child make a decision, but around their early teens, 13, 14, their opinion starts to become important, and they'll listen to them, but they still will never let them make that decision. But if you're making your own agreement, this is something you need to decide whether or not you feel the child or children are at that age. Child support, you want to include, one, how it's being calculated. If you're doing it on your own, you want to indicate that, and whether or not in the future you want it to be done the same way, because we have in New Jersey a child support guidelines which tells you what it should be, and some people deviate. Your agreement should say if you're deviating, why you deviated, and whether or not you want to deviate in the future. Based on some cases that came down, I'm not going to take the time here to go through that, but it's just important. It'll save you a lot of hassle in the future. Things to include: medical insurance. Not the total cost, but the increase that you pay for having a family plan gets added into child support and then divided between the two parents. College contribution, you can address it depending on the age of the children. The most common language that's included is your parents will contribute based on their ability at the time, but you at least want to have some language in there because that would suggest the agreement to at least have college contribution. You never know what the law is going to be, especially if you have a young child. Extracurricular activities, child support guidelines do include that in child support. You may want to have a separate agreement for that, and if so, how that's going to be resolved. Extracurricular is becoming very, very expensive for children. We have a lot of activities with sports events and traveling, sporting competitions. You have play dates for little kids, and extracurricular is not the same as when we did the child support guidelines, 30-something years ago maybe. So you would definitely want to consider extracurricular activities as an addition. Right of first refusal, something I often encourage clients to seek, and that basically saying that if the other person isn't going to be able to exercise their parenting time and would be using a babysitter or daycare, and the first parent is free, that parent should have the right to have the child. Why should the child sit with a stranger? So let's move on to the tax aspects of an uncontested divorce. I'm not going to go deep into this. If you do have any of these issues, I recommend you speak with an attorney and an accountant. First is alimony. Alimony has taxable consequences to both the paying person and the recipient. A special note, this webinar is being done November 2017. There's currently a tax proposal by President Trump to eliminate the deductibility of alimony payments. Now, I don't know where that's going to go, and I don't know when you're going to be watching this, if those are watching in the future, but that's, may be significantly different going forward. Child support does not have a tax consequence, so it's important to understand that if you make an agreement that's outside of the child support guidelines. Pendente lei support, this is the support that a court orders while divorce is pending. The court is allowed to make it allocated or unallocated. What that means is whether or not some of it or all of it will be tax deductible for alimony. If you're making an agreement, you want to determine either how much is allocated and not allocated as support, whereas alimony, or at least you want to write in there that you have the right to allocate it at the end of the case, which brings it to a Malamo versus Malamo case. That's the case that actually says you have the right to retroactively adjust support if it was calculated the wrong way. But then they support, temporary support. Next case to know about is Sheridan versus Sheridan, which says the case stood for tax evasion. Basically says if you testify to the commission of a crime on the record before a judge, the judge is obligated to contact the prosecutor's office. In the case of tax evasion, I believe the judge is required to also notify the IRS. It generally comes up in the context of tax evasion in context of divorce. So this is, if you have a shared issue, tax evasion, tax avoidance, underpayment, this is more of a reason why you might want to try to have an uncontested out of court case. Innocent spouse is if you are involved in a case where there's, underreporting or tax evasion, you weren't aware of it. There are several different methods of relief the Internal Revenue Service will provide for you or does offer to you. They're beyond the scope of this, so I'm not going to go into them, but there are several available. You should look into them if you're involved that way. And lastly is counsel fees. If one of you or both of you have an attorney and it is becoming a settled case, so it becomes uncontested, you want to resolve how fees are being paid. Usually it's each other pay their own, but you want to have that in your agreement too. Moving right along, tax aspects continued. Realty transfer fee. This is usually for residents. If you're transferring it, you have to do it within 90 days. You have to transfer the deed within 90 days of your divorce, or there could be a realty transfer fee. It's based, I believe, on the portion of the mortgage on the property. There could be capital gains and losses that you need to figure out. Now, most of the time, your transfers of assets in a divorce are not going to have a tax trigger, but you need to consider what tax triggers will occur in the future. So if you're taking one asset out of a divorce, you need to know what your future tax consequences are going to be. Like, for instance, real quick, a lot of times one spouse will keep a home, and another spouse will keep a retirement account. And the dollar values net themselves out. But one, if you sell a house, you might have a capital gains. If you take out a retirement account, you could have capital gains, you could have penalties and income tax. So you need to know how the tax consequences of the assets will be affected later after the divorce. There's the dependent deduction. This is a case that does a little discussion about it. Basically, the IRS guidelines say that the person with custody is presumed to be the person entitled to the deduction unless you fill out a form 8832, but you can agree to give the other spouse the dependent deduction. Most of the time, courts and people work to share the deduction either by each taking a certain child or alternating when there's an uneven number of children. Tax consequences to child care medical expenses. There are sometimes tax deductible aspects to this. They also get factored into child support, so you want to understand fully how those taxes are going to affect you, both positive and negatively. You should always get tax advice, as I said before. Now, this part on here, I'm actually not sure what the tax aspects, if you have other dependents, would be. I don't know how it made it into my PowerPoint. If you do have other dependents, it's important for child support purposes and the dependent deductions, as we talked about, but not really significant to determining whether or not you have or should have what's considered an uncontested case. More issues to consider: college expenses. Not that they're deductible, but outside of tuition and room and board, there's going to be fees and books, and sometimes there's car insurance. You need to determine how to do that. The IRS is not going to be bound to any tax agreement, so you want to have, if you have issues like we mentioned before about like Sheridan or child care issues, you want to make language that the other person will protect you and indemnify you if there is a tax issue. If you do not receive the spousal relief the Internal Revenue provides, you want to make sure that there's language that the other person will protect you, because if you make an agreement, there's a tax consequence that falls onto you. The IRS is not bound by your agreement. They'll come after you. Again, seek advice of a tax professional. I can't say that enough. That often becomes important, and again, with the IRS issues I was talking about, if you have to amend old tax returns, a lot of times you discover things when you're getting divorced that maybe your spouse was creative in how many deductions or dependents they took. Maybe they didn't report their income if they were self-employed properly. And you may need to go back and amend the tax return so that you're aware of what the tax liability will be before you get divorced and make your agreement. Another issue to consider with taxes: marriage filing joint, marriage filing separate. Obviously, maybe not to you, but the tax rates are going to be significantly different, but the protections and remedies may also be. So, it's financially advantageous to file married joint But if you have a spouse who may be hiding income or not disclosing income or have tax problems, you may not want to file that way. You might want to take the higher rate and have greater protection. When it comes to filing, you have to know that you cannot file jointly for the year you were divorced. So, for instance, as I said, we're doing this in November. If you get divorced in December and you think you're going to file together and share on the return, it's not going to happen. You have to file separately, and you need to account for that in your agreement. Sometimes, if you're close to the end of the year, a judge will allow you to get divorced but not put the paperwork through and signed until after January, so that you can be divorced and know that you're free and move on with your life, but you can preserve the right to file your taxes together the following year. Penalties for early withdrawals, I was saying before, another thing to consider when you're dividing your assets and retirement accounts. You need to account for the inability to take out early, and if you're going to need to, then you want to know what the consequences of that are going to be beforehand. Now, next most significant issue in divorces is the equitable distribution of assets and debts. Now, generally, even though it's not equal distribution, more often than not, it is a 50-50 split. But there's still a lot of things you need to know. First is, when does that cutoff date begin? When do we stop evaluating when we share the assets? And that is generally the date of your complaint filing. Now, the law says that that's the starting point, but it also allows for another date if more appropriate. So, for instance, if you physically separated a year earlier, or you got a final restraining order that legally and physically separated you, it might make more sense to have the date be on that date, because you don't necessarily want to have a responsibility for debts that were incurred while the person was living separately. And if that's the case, you shouldn't share any assets either. Exchange accounts and other statements, that's what you want to do in order to ascertain the assets and debts before making an agreement. And even if you believe that it's fair, you want to get accounts and not only verify the assets, the values, but verify that they have not been changed recently. There haven't been any transfers or any dissipation of assets. You should get appraisals and valuations if there's complicated assets, even not complicated assets, like a home. You should get an appraisal for. If there's a retirement account, it's not just necessarily right to say, well, we're going to split it in half, especially if you're in the military on either side. I can't go into that again either because it's much more lengthy, but you need to understand how these assets work before you can agree to divide them. Principal and interest, obviously this is going to account for a part of the fairness or part of the equity in the division. Both what is the principal and what is the interest that's being generated off of the assets that may be divided. Do you need trust planning? One, to avoid future tax consequences, possibly as estate planning for you and your children and your future generations. You need to determine whether any of the assets were premarital inheritance or gifts. These are generally going to be exempt from equitable distribution to a large extent. Not entirely. In a moment, I'll talk about active and passive assets. And when I talk about active and passive assets, that relates to premarital inheritance and gifts that change in value over time that may not always be exempt assets like I'm saying here, but for generally speaking they are, and you need to know which ones they have and consider that. Marital versus non-marital expenses, expenditures. Again, you'll have credit card debts. They are considered marital debts when they were used to foster the marital relationship. So if you have a spouse has a credit card debt because they took their paramour on a vacation, it's not a marital debt. And you want to get the statements to ensure that you're not splitting debts like that. More tips on equitable distribution. Like I was saying before about the house, you can't offset and adjust. You don't need to actually physically divide assets and sell off assets and take the cash. You can agree to one keeping the house, another keeping the retirement account. Any division that you think is fair, the courts will generally accept. Active and passive, what I was telling you before, relates often to premarital and inheritances. Active assets, and this is a very deep subject too, but so I can only touch on it briefly. Active assets are assets that become more valuable because of your and your spouse's joint efforts, like running a business together, living in a home and making mortgage payments. Those are active. Passive assets change in value because of the change in time or market conditions, like a retirement account or a stock investment. So an active asset, for instance, real quick, changes the exempt status of premarital assets, meaning if you owned a home before you got married, and that's premarital, but it's active because you're living in it, you're paying mortgage and taxes, you're paying upkeep. When your spouse moves into that premarital home and contributes to the upkeep and to the bills and raises a family, that active asset, that postmarital portion of the value of the house, is marital because it's active. Now, if you have a passive account, like an IRA, and it becomes more valuable after you got married, that does not change the value, or does not change the exemption of it because it's passive. So active changes premarital and inheritances, and passive does not, generally speaking. Business interests are very significant. Not only do you need to figure out the income for support purposes, but you need to figure out the value. In the divorce law, there's a gross inequity right now, in my opinion, that I think will eventually disappear. But for right now, it's here. And that says if there's a business, the business has to be valued, and the person running the business needs to buy out the share from the other spouse. And the reason why I say it's unfair is there are many, many businesses that really have no value whatsoever. If you're a one-man electrician and you have a truck and you get calls to your cell phone, nobody's going to buy that business. So it has no real value. But if it's generating income and has a client list, an appraisal will determine if there's a business value to it, and you will have to pay your spouse for keeping it. And you can't usually say, well, then I'll just get rid of it, because they'll impute your income at that and say that you're dissipating assets. So you're kind of stuck paying for something that's of no real value, and then the payment of it, sometimes taxes, having to service the debt to pay for it, to pay your spouse for it, sometimes taxes the company so much that it starts generating less and less income. Sorry, go off on a tangent because I really have a problem with that area of the law right now. Equitable distribution, as I said before, transfers of assets are generally not taxable. Important to realize, but you should state that in your property settlement agreement in case either the law changes or there is some asset or tax consequence that you did not receive. When that gets triggered later, you can revisit because the intention in your agreement states it should have been non-taxable. But like I said before, you got to consider the tax consequences, capital gain, realty transfer tax, just reiterating that. Many people, as not just offsetting, but will keep their own assets as a way of simplifying. So a lot of times with retirement accounts more often, each will keep their own, even though it may actually be a different value. And that's often because it's easier and a lot cheaper. I mean, there's a lot of costs that get associated with valuing pension accounts. You have to get an actuary to determine the value. You have to get a company, usually a company, to draft a quadro, qualified domestic relations order. Most lawyers won't do that. You can equalize values like vehicles. You can each keep your own car and make a payment if one's keeping one that's more valuable, so you don't need to sell it. And again, I was saying a moment ago that quadros are needed for pensions, so that's usually going back to each keeping his or her own. All right, look pretty good on time. I'm going to keep moving along. I hope I'm not going or talking too fast for you. Now let's talk about how to write a property settlement agreement. Some people call it a marital settlement agreement. Some call it like an intermarital settlement agreement. I call it a property settlement agreement, but all the terms are going to be the same thing. There's going to be two main pieces. There's always a lot of boilerplate when lawyers do it, and a lot of essential terms. Now, in my opinion, I'm calling it boilerplate, but that's another pet peeve of mine because there's significant issues. And when people try to sneak them in saying they're boilerplate, but they really greatly affect your rights, you should be reading them. But the essential terms like division of assets, your parenting plan, that's separate, and that takes a much greater care and concern when you're drafting them. It must be signed and notarized. Some people try to skip over the notarized part. I don't think that's a good idea because if they dispute it, then it's hard to prove that they actually are bound by it. Speaking of being bound, you are bound by the four corners, which means you're bound by what it says. If it does not say it, you cannot argue it, even if it was intended. And the common example of problem in that realm comes up like when you have an agreement to sell a house or a refinance. Like let's say one spouse is keeping a house and paying the other spouse in 90 days. In 90 days, they haven't done it, and you want to throw them out of the house and have listed for sale. If your agreement doesn't say what happens in 90 days, the court's not going to do it. You have to specify what the trigger is for every contingency. If you want to change child support in your future, if you want to change parenting time, like I said earlier, with your change of circumstance, you need to enunciate this because otherwise you're bound by what's in and what's not in your agreement. You do, like I said earlier, want to write in the language of flexibility, how if there are issues, how they get resolved. You may even want to just put in language that you're intending to be flexible. That in and of itself can say something to a court later if you have to re-examine some of your issues. Change of circumstances, again, you want to put in specifically what are going to be the change of circumstances, not just contemplate them, like I said earlier, with child custody. You want to say at what age do you review child support? At what age are you reviewing custody? What kind of college are you willing or not willing to pay for? I may actually, I don't know if I get into that later or not. I think we do. If there's a waiver of alimony, you want to state that it's permanent. You want to put that it's irrevocable. And you also want to put what you contemplated or haven't contemplated as change of circumstances. When we write our settlement agreements, we put in everything. It's almost like a kitchen sink. We contemplated changing the economy, changing taxes, health issues, loss of employment, gaining employment. You name it, you put it in there so that they can't later come back and argue change of circumstances for support. You want to become familiar with a case called Lepus versus Lepus, an anti-Lepus clause. That is language that will or will not allow support to, or mostly alimony, will or will not allow alimony or the terms of a settlement agreement to be changed in the future. Some of them can be, some of them can't be. Depends on whether or not you do or don't use the Lepus versus Lepus language. And you want to have full disclosure. And as I mentioned before, you want to get all the statements in equitable distribution, but you want to write in the settlement agreement that there was full disclosure so that the other side can't come back later and say that you withheld information or they didn't know what they were signing in for. So this should track most of what I said about equitable distribution, but that was considerations for distributing your asset. Now this is about writing up what you should be saying about it. Moving on to more issues. For your settlement agreement, you should maintain, if you have to draft what's called a case information statement. It's a very tedious, very complicated document that courts use to determine support. The law says you should be keeping this in case there are reasons to review support agreements or arrangements in the future. So I do recommend that you retain them. You want to address, like I said, alimony. If there's alimony, you want to address cohabitation, retirement. You want to address if and when it can be changed, when it terminates. Don't just assume because the law says things about cohabitation and retirement that your payments are bound by that. If your agreement does not say it, those rights don't apply. Now, if you're the one receiving it, you may not want them in there. I'm kind of talking from one angle, but children-related expenses in the settlement agreement, don't just do a handshake and say, oh, well, he's agreeing to pay me child support, or you want to write in how much is your child support. You want to write in when is the emancipation going to occur. How did we decide on college contribution? Are we going to be bound by in-state tuition or not? And anything else that your child may incur, extracurricular activities, all of that, whatever needs to be in there. And what anticipated changes you may see. If you have a child with special talents, you might want to build in language that addresses that. Life insurance. If you're having alimony and even child support, you should consider having life insurance to protect against the loss of that if the person who's paying dies. Again, put it in your agreement. If you don't have life insurance, you're not requiring that, put that in your agreement. What is included in college expenses? Put it in your agreement. Are we bound by what's called the Rutgers rule, which is just in-state tuition? Am I paying for lab fees? Am I paying for car insurance? Am I paying child support while the child's at college? Am I paying room and board? These are all issues that should be addressed. Custody and parenting time and relocation, like I said, what you've discussed has to be in there. I also usually recommend, if you're the non-custodial parent or the one that wants to prevent relocation in the future, put in language how it's harmful to the child to be relocated away from you, or that it's harmful for the child to live more than 15 miles from the other parent. You want to have language that talks about the enforceability being in New Jersey. That's usually given, but I still recommend it, and obviously it's always going to be in our agreements. You want to address specifically if there are any legal fees, how they're being paid. Like I said earlier, you make sure it's now in your agreement. And you may want to have an annual exchange of income information. If you have support, especially child support, you want to know when it's changing, when it might be appropriate to modify it. Now let's talk about when alimony makes sense. Alimony is a complicated subject because there's several criteria to be used. But first, if there's a long-term marriage, the longer the marriage, not only the longer, not more likely it's an alimony case, but the longer the term would be. If you have a substantial discrepancy in income, if you have one parent who is a stay-at-home parent, a student, or is disabled, there's temporary support like I talked about. You can also consider support in terms of a short-term marriage or anything. I usually recommend to give assistance to people either moving out, you want to get like first and last month's rent, moving expenses. You can call that alimony and it helps the person make a transition. Other types of support, penality that we talked about, LDA, which is limited duration alimony, ODA, which is open duration alimony, rehabilitative, and reimbursement. These are the general types of alimony permitted under statute. You should understand. I can't go into all of them. Obviously, I think I did a webinar already that goes into them on my website, nicklandlawgroup.com. But you need to understand which one you're agreeing to and actually put that into your agreement because each one has a different reason for modification or termination. And you need to be familiar with that. Alimony can be lump sum or step down. You can pay all one time, and sometimes you change the tax consequences because you're getting the current use of the money instead of waiting years to get it. You can also have a decrease over time, step down payment, so it doesn't have to be the same amount. Going forward, as the lower earning spouse's income increases, the support may decrease. One thing to keep in mind, again, the topic I can't go into at length here, but there's something called the alimony recapture rule. The IRS has that if alimony is front-loaded or changes in the future by a certain amount, I think it's like $15,000 in the first 3 years, that the court may, or the IRS may recategorize the alimony as child support, which flips the tax consequences. Elastic formula consideration of bonuses. Sometimes I recommend putting in a review if not just a review, but also an elastic formula, meaning if you have a bonus-based compensation package, like let's say you're a Merrill Lynch, employee, and you get $150,000 bonus or $150,000 base salary and a $500,000 bonus, I don't usually recommend, at least if that's my client, recommend alimony based on a fixed sum because the bonus may change significantly. You may get no bonus next year, and your salary is $150,000. So you can have a fixed percentage, like 25% of the salary and 25% of the bonus, so that you're both sharing in that risk. Now, again, depending on where you're standing in this case, depends on whether or not you want that kind of formula, but it's something that you should consider. Consider income from all sources, including that derived from property. So there's going to be rental incomes, there may be interest incomes, there may be trust distributions you should consider. If that's involved, that will affect whether or not there is or is not alimony. Reduce supporting spouse's taxable income. Another thing to consider, because what can sometimes happen is the payment of alimony can sometimes change the tax rates that each party is at, and sometimes negate what you're trying to accomplish. Sometimes the payment of alimony triggers a higher tax consequence than you considered. Last is imputation of income. If there's a spouse that's maybe not working enough, but they could or should be, you might want to inflate their income, and that will change whether or not there is or should be alimony. All right, so basics for drafting your complaint. I'm going to go quickly because I'm a little at the end of my time. I do like to leave some time for questions. Generally, not actually no fault. I say it's no fault, but technically it's irreconcilable differences. But you just have to use certain language that says they've arisen in the last 6 months, that we're not going to have a reasonable chance of reconciliation. There are forms you can download from the New Jersey Judiciary website that will give you the basic fill-in-the-blank information. Basic information needed: when you were married, how long you've lived in New Jersey, children's names, birthdays, basically. Again, you have to, like I said, you have to live in New Jersey for a year. For reconcilable differences, you have to have been in the county for 6 months. There are several other forms that will be attached to the complaint that you need to do. The summons, which usually comes with the complaint, it's kind of a fill-in-the-blank. Confidential litigant information statement, CLIS. You get that from the court. That must be submitted. to the court with your filing, or it'll be returned. Affidavit of insurance, if you're using the form, it'll be attached, and you just have to fill it out, as well as a certification of non-military service, which is saying that your spouse is not in the active military. A couple things more about drafting your complaint. One is you can ask in the complaint that the court take your settlement and incorporate it into your judgment. You should have language that says that specifically so that it becomes part of your divorce. You may want an acknowledgement of service so the other person can sign saying they got the complaint from you, so you don't have to have it served. And service instructions will be inside of the packet if you're going to go that direction. You can also give a waiver of 35 days to answer, which means that the other spouse that's getting it and signing the acknowledgement of service can agree that they don't need to be heard because you have an agreement, and that agreement is going to be the basis for it. And the next document you're going to need in that case, if it's uncontested, well, maybe if it's uncontested, if your spouse wants to be heard at the final hearing, you won't need this, which is a request and a default. But if you're waiving their right to answer, then you need to request and a default. Again, another form you can probably get online, I think. Now, real quick, what to expect at your court hearing. I usually tell people try to block out a few hours because they say everything's for 8:30, but nothing starts at 8:30. Figure out where the parking is going to be because you don't want to be late, even though, like I said, it'll start early. And you may be sitting a long time waiting for the judge even to come out and take your case. There could be many before you. Now, once you actually get to your hearing, the final hearing usually takes like 5 or 10 minutes, maybe 10 to 15, depending on how long people talk. Simple yes or no questions. The judge will ask you several of them. If you're unrepresented, the judge will lead you. He or she just wants to make sure that the agreement you had was voluntary, you understood it, you weren't coerced or threatened into it, and you know that you're not going to a trial to have the issue decided. Next, and sometimes first, but also the judge will ask you about the irreconcilable differences that you mentioned in your paperwork, just that you have them, it lasted 6 months, you're not going to reconcile. You will be at different tables, so you don't need to sit together. You won't be sitting together if there's a restraining order. That will give a lot of people comfort. You should bring your marriage certificate. I've only had it once or twice actually be asked, but 1 or 2 times it was asked. It would have been really bad if you didn't have it. And if you don't have it, the judge will usually understand that and let you go without it, but if you have it, bring it. Court will not read your agreement. He or she will not pass on whether it's fair or not. They will simply want to make sure that you know and agree that it's fair. If you are resuming your married name, you must put it in your complaint so that you can get at the end. The courts may not, there's ways for the courts to get around that if you haven't, but you don't want to have to go there. Put it in your complaint so you'll get at the end. And then they'll give you a gold seal, usually right when you're there. It's unusual for them to make you come back or send it to you, but sometimes judges are busy. They don't get to, but almost 99% of the time it's going to be given to you that day. So that looks like it. I'm going to quickly check to see if I have any questions in my chat box. I don't see any. I'll hang out for another minute or two, see if anybody does have any questions. And of course, when we hang up, if you think of questions, you have my email address from the registration. You can send me an email. You can call my office at 973-562-0100. You can also go to my website, makinglawguru.com. That might answer your question. There might be information there for you. Or just, like I said, give us a call. All right, I'm not seeing any information, so I'm going to close out and wish you all good night. I will be having my seminar or my webinar next month. I think it's scheduled for the 28th December, Thursday. It's usually going to be the last Thursday of every month. So good night. Hope this was helpful.